So it is unconstitutional for a public official to block someone on Twitter. I will take questions I never thought the Court of Appeal would have to answer for 800, Alex. Yes, it is me, Viva Frei, Montreal litigator turned YouTuber. I shaved and I feel ugly and naked, but the hair will grow back and it is not normal for anyone to have such a physical attachment to hair. Okay, moving on. The Knight First Amendment Institute at Columbia University and other plaintiffs recently sued Donald Trump because he blocked some of the plaintiffs from his account on Twitter. The Knight First Amendment Institute at Columbia University was not one of the individual users that was blocked from the president's Twitter account, but they alleged to have been egreged as a result of the individual plaintiffs being blocked and the Knight First Amendment Institute's inability to read those tweets and hear those opinions. Now, the lawsuit in and of itself may seem potentially absurd on its face and certainly a sign of the times. People suing the President of the United States on the basis of a First Amendment constitutional violation because the President blocked them from his Twitter account. That said, as absurd as this might seem on its face, it's actually a very interesting legal question, and the judgment itself is actually very interesting as well.
So let's read it, shall we?
Knight First Amendment Institute at Columbia University. Rebecca Buckwalter, Philip Cohen, Holly Figueroa, Eugene Gu, Brendan Kelly, Joseph Rapp, and Nicholas Pappas. Plaintiffs appellees: Donald J. Trump, President of the United States, and Daniel Scavino, White House Director of Social Media and Assistant to the President. Defendants appellants: Sarah Huckabee Sanders, White House Press Secretary, defendant. And the introductory paragraph basically summarizes the question at law pretty succinctly. Plaintiffs Buckwalter, Cohen, Figueroa, Gu, Neely, Papp, and Pappas, individual plaintiffs, are social media users who were blocked from accessing and interacting with the Twitter account of President Donald J. Trump because they expressed views he disliked. The Knight First Amendment Institute at Columbia University is an organizing alleging a right to hear the speech that the individual plaintiffs would have expressed had they not been blocked. The plaintiffs sued President Trump along with certain White House officials, contending that the blocking violated the First Amendment. The United States District Court for the Southern District of New York found that the, quote, interactive space, end quote, in the account is a public forum and that the exclusion from that space was unconstitutional viewpoint discrimination. We agree, and accordingly, we affirm the judgment of the District Court. And at the very least, the Court of Appeal ends the suspense and lets us know right from the beginning how they are going to render their judgment. Oftentimes, lawyers have to skip to the end of the judgment to see how the court ruled, and the court sort of drafts their judgment like a suspense novel, and it's only about 1/3 of the way through that you have an inkling or know the direction that the court is going. I prefer this method. Rip the band-aid right off, let you know from the beginning whether you won or lost, and now you can read the motives. So let's do that. Now, the facts at issue are relatively straightforward and uncontested. President Trump blocked a number of users from his Twitter account, admittedly as a result of the viewpoints they were expressing, and the question is whether or not in so doing did the president, acting in his capacity as a public official, violate the First Amendment rights of the individuals that he blocked from his Twitter account. Page 4, line 6 reads as follows. The salient issues in this case arise from the decision of the president to use a relatively new type of social media platform to conduct official business and to interact with the public. And this is a very important caveat that the court sets out from the beginning, because they have come to the conclusion that a public official blocking the public from their Twitter account constitutes a First Amendment violation. A lot of people might make the argument that this decision itself is a sign of what's to come as relates to Twitter blocking users from the platform, and whether or not that too constitutes a First Amendment violation. The court says that they are not addressing that particular question right now. We do not consider or decide whether an elected official violates the Constitution by excluding persons from a wholly private social media account, nor do we consider or decide whether private social media companies are bound by the First Amendment when policing their platforms. Critical. Whether or not this decision may apply mutatis mutandis to that question, the court is not answering that question in this decision. That will be for a separate decision later on down the line, presumably. We do conclude, however, that the First Amendment does not permit a public official who utilizes a social media account for all manner of official purposes to exclude persons from an otherwise open, online dialogue because they express views with which the official disagrees. And there you have the framing of the decision. The court is not adjudicating on whether or not it is a First Amendment violation for a public official using a private account for private purposes to block users, nor are they determining whether or not it is a First Amendment violation for Twitter itself to ban or block users. Twitter is a social media platform that allows its users to electronically send messages of a limited length to the public. After creating an account, a user can post their own messages on the platform, referred to as tweeting. Users may also respond to the messages of others, replying, republish the messages of others, retweeting, or convey approval or acknowledgement of another's messages by liking the message. All of users' tweets appear on that user's continuously updated timeline, which is a convenient method of viewing and interacting with that user's tweets. When one user replies to another user's tweets, a comment thread is created. When viewing a tweet, this comment thread appears below the original tweet and includes both first-level replies, replies to the original tweet, and second-level replies, replies to the first-level replies. The comment threads reflect multiple overlapping conversations among and across groups of users and are a large part of what makes Twitter a social media platform. I happen to think there's nothing social about Twitter as a social media platform, but it is definitely an interactive platform where people fight. Moving on. And just to establish some more facts before we get into the meat of the decision and what we can actually take away from this decision, page 6, line 10. President Trump established his account with the handle @RealDonaldTrump in March 2009. No one disputes that before he became president, the account was a purely private one, or that once he leaves office, the account will presumably revert to its private status. This litigation concerns what the account is now. Since his inauguration in January 2017, he has used the account, according to the parties, as a channel for communicating and interacting with the public about his administration. The president's tweets from the account can be viewed by any member of the public without being signed into a Twitter account. However, if a user has been blocked from the account, they cannot view the account's tweets when logged into their account. At the time of the party's stipulation, the account had more than 50 million followers. The president's tweets produce an extraordinarily high level of public engagement, typically generating thousands of replies, some of which in turn generate hundreds of thousands of additional replies. The president has not generally sought to limit who can follow the account, nor has he sought to limit the kind of speech that the users can post in reply to his tweets. And another critical fact comes at page 9. Finally, we note that the National Archives, the agency of government responsible for maintaining the government's record, has concluded that the president's tweets are official records. The Presidential Records Act of 1978 established public ownership of the president's official records. Under the act, presidential records include documentary materials created by the president in the course of conducting activities which relate to or have an effect upon the carrying out of the constitutional, statutory, or other official or ceremonial duties of the president. Duties. Sorry. Another critical fact that also stems from a critical admission. Page 10. In May and June of 2017, the president blocked each of the individual plaintiffs, but not the Knight First Amendment Institute, from the account. The government concedes that each of them was blocked after posting replies in which they criticized the president or his policies, and that they were blocked as a result of their criticism. The government also concedes that because they were blocked, they are unable to view the president's tweets, to directly reply to these tweets, or to use the @RealDonaldTrump webpage to view the comment threads associated with the president's tweets. And an argument that is going to be critical in addressing a secondary issue as to whether or not this constitutes a First Amendment violation can be found later on in this page. The parties agree that without the context of the president's original tweets, it is more difficult to follow the conversation occurring in the comment threads. In addition, the parties have stipulated that as a consequence of their having been blocked, the individual plaintiffs are burdened in their ability to view or directly reply to the president's tweets and to participate in the comment threads associated with the president's tweets. While various workarounds exist that would allow each of the individual plaintiffs to engage with the account, they contend that each is burdensome. And we're going to get into this in greater detail a little later, because there are two issues. One is a First Amendment violation to the freedom of speech, and the other is an unnecessary or undue burden in exercising a First Amendment right, which itself constitutes a violation of the First Amendment. Page 12 summarizes the reasoning behind the district court's decision, the one that's the object of this appeal. It reads as follows. The district court held that the interactive space associated with each tweet constituted a public forum for First Amendment purposes because it was a forum in which other users may directly interact with the content of the tweets by replying to, retweeting, or liking the tweet. The court reasoned that 1. There can be no serious suggestion that the interactive space is incompatible with expressive activity, and 2. The president and his staff hold the account open without restriction to the public at large on a broadly accessible social media platform. As to the government control requirement of the public platform analysis, the court found that the president presents the @RealDonaldTrump account as being a presidential account as opposed to a personal account, and uses the account to take actions that can be taken only by the president as president. The court concluded that because the president and Scavino used the @RealDonaldTrump account for governmental functions, they exercise government control over the relevant aspects of the account, including the blocking function. The court also rejected the idea that speech within the interactive space on the platform is government speech not subject to First Amendment restrictions, concluding that replies to the president's tweets remain the private speech of the replying user. Alright, so that is a very detailed summary of the facts at issue that are going to support the rest of this decision. But to summarize the points at issue, the plaintiffs, the Twitter users who were blocked from President Trump's Twitter feed, are arguing that President Trump's Twitter account, even if it's his personal account that existed prior to becoming president, has become an official government account. They are arguing that the act of being blocked from this platform by the president constitutes viewpoint discrimination and is therefore unconstitutional by nature and constitutes a First Amendment violation. And what is the president's defense to this? The president's defense illustrates a good point in law that when you have strong arguments, don't throw in your weak arguments because they ultimately discredit you and cause you to lose goodwill, thus undermining your otherwise good arguments. And what, at least according to the judgment, did the president raise as his primary, first, and strongest argument? The president's primary argument in his brief is that when he blocked the individual plaintiffs, he was exercising control over a private, personal account. Who thinks the court is going to be convinced by that argument? At oral argument, however, the government conceded the account is not independent of Trump's presidency, choosing instead to argue only that the act of blocking was not a state action. And here, in my humble opinion, is another strategic mistake. It is adding a weaker argument to the already weak argument that ought not have been the primary argument. I don't think a great many people could actually be convinced that the court would agree that when President Donald J. Trump tweets from his personal account, he is only tweeting in his capacity as a private citizen. And then when they concede that the private account is used both for private and presidential purposes, I don't think the court can be expected to accept the argument that when President Trump blocks people, he is only doing it in his capacity as a private individual. My humble opinion is that these are very weak arguments that the court would never accept, and by making them, you are losing goodwill and credibility before the court. What do I think ought to have been the primary strongest argument? That when you block a user from Twitter, you are not violating their First Amendment rights to freedom of speech, because they can still say and do whatever they want on the platform. They just can't do it in President Donald J. Trump's Twitter feed. That said, the court does address this later on, and they do address it in a very logical and coherent manner, irrespective of one's political leanings, but we'll get there. The point right now is that one should not make bad arguments when they have good ones, and by making bad arguments sometimes, even though one has the tendency of throwing everything on the wall, hoping that something sticks, in throwing bad arguments at the wall, you lose credibility in front of the judge and make it easier for them to dismiss your otherwise stronger arguments because you have taken the chance of throwing bad arguments at the wall that the judges are easily and readily going to dismiss. Let's move on. Page 15 is a big admission in law. The president concedes that he blocked the individual plaintiffs because they posted tweets that criticized him or his policies. He also concedes that such criticism is protected speech. The issue then for this court to resolve is whether in blocking the individual plaintiffs from the interactive features of the account, the president acted in a governmental capacity or as a private citizen. Page 16, line 7. No one disputes that the First Amendment restricts government regulation of private speech but does not regulate purely private speech. If, in blocking, the president were acting in a governmental capacity, then he may not discriminate based on viewpoint among the private speech occurring in the account's interactive space. And this touches on the question of viewpoint discrimination, which we also saw in the Fucht Supreme Court decision, that the government may not engage in viewpoint discrimination, meaning that they accept or reject certain speech based on the viewpoint it conveys. And that was the core issue in the provisions of the Lanham Act that did not allow for the registration of scandalous or immoral trademarks, in that the government was deciding which marks to grant or refuse trademarks to based on the viewpoint that they expressed. And the government had refused to grant trademarks to certain viewpoints because they say, for example, condone drug use, and the government didn't want to condone drug use, and therefore they refused to grant a trademark to that viewpoint. Unconstitutional. In this case, you have the admission that President Trump is blocking people because of the viewpoint they are expressing, but the defense is that the president is doing it not in his capacity as president, but in his capacity as a private citizen. An argument which the court doesn't buy, and rightly so. And just to open a parenthesis on a personal note, I have always said that there's nothing really more irritating than someone posting a video on YouTube and disabling comments. Than someone basically saying, here's what I think, but I don't care to hear what you think. Or someone deleting or removing comments that they don't like, as if to say, I want to share something with the world, I want to tell you what I think, but I don't want to hear people criticize me for it. It's disingenuous, and barring extremely offensive, harassing, or violence inciting comments, when someone puts something out there in the public, they have to be ready to deal with the criticism, even if they don't like the viewpoint being expressed in those responses. Parentheses closed. And when I talk about making arguments that one can reasonably anticipate would never be accepted by a judge, let's just see what happens at page 17 of the decision. The government's contention that the president's use of the account during his presidency is private founders in the face of the uncontested evidence in the record of substantial and pervasive government involvement with and control over the account. First, the account is presented by the president and the White House staff as belonging to and operated by the president. The account is registered to Donald J. Trump, 45th President of the United States of America, Washington, D.C. The president has described his use of the account as modern-day presidential. Why on earth lead off with an argument that is not only not supported by the evidence, but utterly contradicted by it, and an argument that you know the judges could never accept? Hindsight is 20/20, and it's always easy to play Monday morning quarterback, but this is not an argument I would have ever led off with, and it's probably not an argument that I would have ever have made because it is so untenable. It is a weak argument. One can anticipate the response to it, one can even draft the response to it, and there are other stronger arguments that ought to have been made first, and probably ought to have been made only. And then to compound what I believe to have been a strategic mistake to have made a bad argument as a primary argument, the president's lawyers further undermine any position that they might later on raise by arguing as follows. Page 19. The government's response is that the president is not acting in his official capacity when he blocks users because that function is available to all users, not only to government officials. It's not a government account, it's a private citizen's account, and when the president tweets from that account, he's tweeting as a private citizen. But if he is tweeting as a public government official, when he blocks users, he's only blocking them as a private citizen. Who can reasonably expect a judge to agree with that? Again, it undermines and does damage to the otherwise stronger and more valid arguments that ought to have been raised as primary arguments. And the court's response to that argument is predictable and reads as follows. Accordingly, the president excluded the individual plaintiffs from government-controlled property when he used the blocking function of the account to exclude disfavored voices. And yesterday, when I was reading this decision, I was trying to come up with a different analogy that would allow people to appreciate the context and what is going on here. People are going to make the argument that Twitter is not itself a government-controlled property. Twitter is a private company offering services to the general public, so when a government official using its account blocks someone, they are not violating the First Amendment because it's not a government-run entity. And this is not a question of politics or political affiliation. The analogy that I came up with to illustrate why this argument should fail is one of a billboard on private property. Let's just say that a privately owned shopping center has a section where they allow people to post billboards. And then the government reserves its own section, posts its own billboards where it makes public announcements and gives people the opportunity to respond or write down comments that they feel appropriate. But then the government comes in and says, no, you can't write down any responses on this billboard because I don't like what you have to say, but you can. And the reason why I can do this is because it's on a wall in a private shopping center and therefore it's not government property. Having a more physical and tangible illustration of what Twitter effectively is can illustrate why the argument cannot possibly be supported. Twitter may be a private company offering services to the general public, but when a public official opens up a Twitter platform and posts comments to which people can respond, the second they start saying who can and who cannot respond and who can and cannot have access to this public billboard is the second they engage in viewpoint discrimination, which is fundamentally unconstitutional. And at page 21, the court says as much. Once it is established that the president is a government actor with respect to his use of the account, viewpoint discrimination violates the First Amendment. Opening an instrumentality of communication for indiscriminate use by the general public creates a public platform. And again, we shouldn't get confused between the public platform as relates to a government official's Twitter feed versus the public platform as relates to Twitter as an overall entity. The court has said they are not addressing that question in this particular decision, but as I've said in previous vlogs, I suspect that question is going to come before the courts sooner than later. Is Twitter a public platform or are they a publisher? Regardless, if you haven't seen my previous video on that subject, I'll link it right here. Go check it out. It's a good one. The account was intentionally open for public discussion when the president, upon assuming office, repeatedly used the account as an official vehicle for governance and made its interactive features accessible to the public without limitation. We hold that this conduct created a public platform. If the account is a forum, public or otherwise, viewpoint discrimination is not permitted. And we can refer back to the Fucht Supreme Court decision. We can refer back to the Mattel versus Tam Supreme Court decision. The government cannot engage in discrimination because of the substance of the viewpoint being expressed. First Amendment violation. And finally, at page 24, we get to what I humbly feel to be the strongest argument the government could have made and what they ought to have made as their primary and potentially only argument. That the President of the United States, or any other public official for that matter, acting in that capacity, is not violating someone's First Amendment right to freedom of speech by blocking them from their Twitter feed. The user that is so blocked is not prevented from speaking their mind. The user so blocked is not prevented from saying what they want to say. The user so blocked is not even prevented from responding to the account from which they were blocked. There are, in fact, various workarounds, some of which may violate the terms of service of Twitter, which I don't consider to be legitimate workarounds, but there are other legitimate workarounds which might be inconvenient or might be a little bit irritating, but which nonetheless allow for full freedom of speech and freedom of expression. Page 24, line 7. The government does not challenge the district court's conclusion that the speech in which individual plaintiffs seek to engage is protected speech. Instead, it argues that blocking did not ban or burden anyone's free speech. Specifically, the government contends that the individual plaintiffs were not prevented from speaking because the only material impact that blocking has on the individual plaintiff's ability to express themselves on Twitter is that it prevents them from speaking directly to Donald Trump by replying to his tweets on the @RealDonaldTrump webpage. One of the workarounds suggested in the decision as to how a blocked user could nonetheless get back onto the president's Twitter feed involved creating a new or alternate account. Now, I do believe this might actually violate Twitter's terms of service, that is, creating an alternate account to get around a ban. So I don't actually consider that to be a plausible or legitimate workaround. Some of the other workarounds involve screenshotting the president's tweet and replying to it on one's own Twitter feed. Others involve a sort of search where you can search for people's responses to the president's tweets and respond to those responses, thereby sort of circumventing the block by responding to a response to the Twitter feed from which you were blocked. But the court brings up an issue not only of a violation of freedom of speech, but an undue burden on someone's exercise of freedom of speech. And it's based on this undue burden that the court disagrees with this position raised by the government. Whether or not the court would have been more amenable to accepting this argument had credibility not been lost by raising two primary arguments which were themselves manifestly untenable, we'll never know. But the court nonetheless does not accept this argument for reasons that seem to be pretty well founded in constitutional law. Page 26, line 4. Tellingly, the government concedes that these workarounds burden the individual plaintiff's speech, and burdens to speech as well as outright bans run afoul of the First Amendment. And there is the legal distinction to dismiss this argument as well. Burdens to freedom of speech constitute violations to freedom of speech. The government may no more silence unwanted speech by burdening its utterance than by censoring its content. The distinction between laws burdening censoring and laws banning speech is but a matter of degree. The government's content-based burdens must satisfy the same rigorous scrutiny as its content-based bans. When the government has discriminated against the speaker based on the speaker's viewpoint, the ability to engage in other speech does not cure that constitutional shortcoming. And there you have a seemingly well-justified and jurisprudential response to that argument. Undue burdening of the freedom of speech constitutes a violation, and even if there are other workarounds, to the extent that they burden the individual's right to freedom of speech on a public forum run by a government official in their capacity as a government official violates the First Amendment. And the Court of Appeal ends its decision with the following thoughts. The irony in all of this is that we write at a time in the history of this nation when the conduct of our government and its officials is subject to wide open, robust debate. The debate encompasses an extraordinarily broad range of ideas and viewpoints and generates a level of passion and intensity the likes of which have rarely been seen. The debate, as uncomfortable and unpleasant as it frequently may be, is nonetheless a good thing. In resolving this appeal, we remind the litigants and the public that if the First Amendment means anything, it means that the best response to disfavored speech on matters of public concern is more speech, not less. And I think we can all agree with that. The major question is going to be whether or not the principles set out in this decision are going to apply equally to all government officials or only more equally to some. Time will tell, but only time will tell. But at the very least, now you know your facts. If you like this content, be sure to like, share, subscribe, hit the notification bell, leave a comment, drop a thumbs up. If you want some merch, get some Vlog Dog or some vlog shirts. The links are below. And now you know your vlog. Peace out. Boom!